Nevertheless, moving forward, we recognize the Honorable Rodriguez.
Thank you very much, Madam Chair. The second act of betrayal is found on page 23. The charge: President Marcos betrayed public trust by, very important word, abusing, because betrayal of public trust, abuse. To solely, next issue, solely authorize the release of unprogrammed appropriations, channeling 213 billion in standby funds, and so forth and so on. So, abuse, and then solely. Now, let's go now to the next page. The legal framework that they provided already provides the ammunition why the President cannot be responsible. The legal framework states that precisely Section 35 of the Administrative Code of 1987 and the Special Provision number 1 of the 2024. They say establish an ambiguous is not big ambiguous because it's not ambiguous legal reality. The reality, according to them, is that the President personally controls the release of unprogrammed funds. Of course, being the chief executive, all the funds should go, especially under the law on unprogrammed funds. The law provides that the President will be the one issuing it. So already clear that the President is empowered by law, two provisions of law, Administrative Code and the General Appropriations Law. And then, 99, expenditures from this lump sum appropriation must be made in accordance with the special budget. You see, it's not solely the President. A special budget to be approved by the President because it comes first from the department, it goes to the DBM studies it, and then recommends to the President. He is not the sole. It's not out of nowhere. He will now release program funds. So, he, in fact, would support the fact that this particular ground has no sufficiency. Now, let's go to the judicial confirmation of abuse. Citing the case of Pimentel versus the House of Representatives, Special Provision 1D of the 2024 GAA, they say that this is a confirmation of abuse. I disagree. The Supreme Court struck down PD Presidential Provision number 1D. Why? Because the doctrine of operative facts, as early as 1971, second year, College of Law, 1977. The case of Serrano de Agbayani versus PNB already establishes the doctrine of operative facts. What is that? All the laws are valid and all acts of the executive or whatever official is valid until the law is declared unconstitutional. This case of Serrano de Agbayani versus PNB was followed by a litany of cases on operative facts, which are Belhica versus Ochoa Jr. and Bandadas versus Ochoa Jr. Now, Madam Chair, the operative fact means that everything, Secretary Recto has the authority because we have the provision of section of the special provision. We have a provision in our GAA that authorizes that excess funds of all government-controlled corporations may be remitted to the national government. Although he was wrong. They were wrong, but the law acknowledges that they were valid when they were transferred. In fact, the decision says that they are not responsible. Why? Because of the doctrine of operative fact. So therefore, Madam Chair, this entire charge falls under the doctrine of operative facts. Recto was right. Recto was doing what was right at the time. It was not yet unconstitutional. The President was right in having this release because that is the doctrine of operative fact. So I'd like the complainants to read. Serrano de Agbayani versus PNB, 1971 case, 55 years ago. And is still now being done by all the decisions, including Pimentel III. So therefore, Madam Chair, how can we blame the President on this particular release coming from unprogrammed funds when they were legal with the special provisions being legal at the time, declared to be unconstitutional later on. So, Madam Chair, then let's go back to the others so that we can have the causal connection. Because all of this will fall already, but I'd like to just emphasize for the record. The causal link to corruption. Here, this is now the vague statement that would make the signing of the President the act of signing into law our GAA, which is deliberated by the House and the Senate. The signing will become an illegal act and subject to impeachment. This is what is stated in 104. By certifying the 2024 budget as urgent and signing it into law with special provision 1D, he is now therefore directly enabled the unconstitutional siphoning. At the time, it cannot be unconstitutional kasi wala pa nga. At the time that this was transferred, there was no declaration of unconstitutionality. Again, the doctrine of operative facts. So, then, after this, we go now to paragraph B, circumvention of congressional oversight. How can there be a circumvention when these program funds released are not anymore under the law subject back? Otherwise, every release of the President, the complainants would want the Congress to be the one to decide through oversight. How can we do that? There's just so many items in the program funds. And that's why the Chief Executive is given that power by law to be able to release. There is no, as far as we are concerned, oversight function that we can reverse the President. The President can veto, and that is the time we can reverse him. But after that is signed, it is already law. So there is also nothing in paragraph B, circumvention of congressional oversight. Then we have again legal conclusions. You do not put in a complaint your legal conclusions. The judge will decide on that. Civil cases, there can be no legal conclusion because that is subject. That is why you are recital of facts, so that the judge, in this case, the Committee on Justice, will decide whether there is a basis to consider to continue with the trial or not. So, Madam Chair, clearly, the doctrine of operative facts absolves everybody in relation to unprogrammed funds. In relation to presidential of the special provision number 1 of the 2024. Doctrine of operative facts. As early as 1971, Serrano de Agbayani versus PNB. Moratorium case, the moratorium of non-payment of utang to the government on housing. So, all the collection were valid until it was declared unconstitutional. So therefore, Madam Chair, it is clear that there is no basis in fact to be able to proceed even hearing this case because everybody is absolved already. That is the law. And the law is read into all complaints. Thank you, Madam Chair.
What distinguishes a dean of College of Law from a lawyer? A lawyer knows the law, but the dean knows the evolution of the law.
No, the difference, Madam Chair, from a lawyer is that how to become a dean. A lawyer who does not know how to practice law, he becomes a law professor. And a lawyer who loses his cases and does not know how to teach, he becomes the dean of the College of Law. San Sebastian College of Law.
Thank you,
Madam
Honorable
Chair.
Rodriguez.
Madam Chair, I beg to respectfully disagree with
Okay, let's
Congressman
give
Rufus.
chance to break the monotony of this very
I disagree also,
heated
Madam Chair.
discussion. Let's give
36
chance
years
to
po ako.
another Dean, Dean Jokno, to react to the statement of Dean Rodriguez.
36 years po ako kung Rufus nag-practice bago po ako naupo.
Exception
bilang
of
dean.
Chel Jokno, of course.
Madam Chair, I
Thank
will
you,
be
Madam
signing the
Chair.
impeachment complaint of Congressman Jokno against Congressman Rufus Rodriguez.
All